years now. And he's always been very high energy when it comes to KW and the real estate things. He and I don't always agree 100% on everything, but for the most part, I love his tenacity and his drive, and he genuinely wants to help everybody. And that is something that I respect quite a bit. He's always available. Anybody needs help. And even if he doesn't have a lot of time, he finds time to help. Or as he would say, he finds priority to help.
That's good. Yeah, that's good.
Well, let's jump in here. I want to be conscious of everybody's time. Griffin, thank you for jumping on our call today to talk about how bankruptcy can enter into when we're calling pre-foreclosures. I did email you some questions. I don't know if you were able to look at those yet this morning.
I did.
I'm going to sit there and let you run the meeting. If you have slides and stuff you want to share, that's great. I'll let you go ahead and do that. But first off, Griffin, tell us who you are and how you and I got to know each other.
Sure. My name is Griffin Dunham. I've been an attorney for 22 years now, and spent a majority of that time practicing bankruptcy and real estate. And I'm an owner of Icon Title and one of the attorneys with Icon Title. And, you know, the company's here just to try to benefit Keller Williams, and all the agents provide additional resources. You can get title insurance anywhere. And so the difference maker or the differentiator is that we try to provide the resources to the agents also, whether that's asking questions about a potential property, asking questions about what the title looks like, asking questions about boundary disputes, easements, you name it. We want to try to clear the deck before it becomes a problem prior to closing. And so we always want to be a resource and provide education to any of the agents whenever we can. Bankruptcy is an interesting topic because it's not well known, but it's very scary to a lot of people. I apologize in advance. I'm going to speak fast because I want to respect your time. And Wes, I should ask the question first. How much time do you want me to be able to speak before I turn it back over?
Well, I want to say it's kind of like what Rob talked about in the meeting. If you're energetic and you feel the faith talking to you, you know, like the preacher said, then you just keep right on speaking. But, you know, the congregation may have to leave at noon. Okay. So we'll see when they have to go.
Understood. All right. And this is intended to be a little bit of a free flow of communication. So there should be dialogue. If you have questions, you can interject anytime. I don't take offense to it. And if you don't understand something, please jump in and say, can you restate that in a little bit clearer fashion? And I'm happy to do so. So bankruptcy is scary for a lot of people just because they don't understand what the consequences are, and they think that it's bad. Oh, I'm not going to be able to have credit for 7 years. And some of that is true. Some of that is not true. The purpose of my, I think, role today is to answer some of the questions, answer all the questions that the Wes has brought, because those questions and the answers to them are going to help you potentially target some of the properties that are going to be listed for sale. And also, I'm going to toss out a different concept too towards the end about tax sales, but that's a different beast in and of itself. That is a pretty good opportunity to try to farm those, and they're fairly easy to find. So bankruptcy, the first thing you need to know, there are 3 chapters of bankruptcy. There's chapter 7, which everybody's heard about, chapter 13 and chapter 11. Chapter 7 is available for businesses and individuals. That's a straight liquidation. That's where you file for bankruptcy, a trustee gets appointed, and unless it's an exempt asset like a retirement account, or if it's something that is a religious item, clothing, really truly personal items, those are considered exempt. Everything else, a trustee automatically on day one, they get control over the asset and they can dispose of it however they want, and they liquidate it for the benefit of the creditors. So they liquidate it, and then the proceeds get dispersed out to all creditors. In the event of real estate, they first have to pay off the deed of trust, the mortgage that's associated with it, and then the remainder would overflow to the rest of the creditors. So when you think of chapter 7, think fire sale. Chapter 13 is the second most common, I'd say, depending upon the district, between 50 and 75% of cases that are filed are chapter 7s. And then about 50 to 75%, depending upon the district, are chapter 13s. Chapter 13 is a reorganization. That's where an individual, not a business, individual files for bankruptcy, and they say to the world, I want to keep all my assets. However, I have the ability to repay. And so my ability to repay is going to be based on my projected disposable income going for the next 3 or 5 years, depending upon how much money they anticipate making. Chapter 13 is for wage earners, W-2s, sometimes 1099s. And in that situation, they just propose what's called a plan of reorganization. And that plan details how much money they're going to have left over to pay creditors. And that payment then is better than a liquidation where creditors might not get anything. So they are saying, I want to keep my assets, and in exchange, I'm going to pay a little bit more than nothing, like what would happen in most Chapter 7 cases. And then Chapter 11 is less than 1% of the cases, but those are the big business reorganizations that you see in very high net worth individuals. The sale of real estate occurs in all 3 of the chapters. It's just a different seller depending upon the chapter. Once so for Chapter 7 purposes, like I said, a trustee is appointed. So the trustee actually becomes the seller. So point number 1 is, if you ever see a bankruptcy case that's filed and it's a Chapter 7, just know that your client would not be the owner of the property, because as soon as that bankruptcy was filed, the owner of the property became the trustee. So your client would be the trustee. That's why there is, I think, a high level of importance and stress to be placed on building a relationship with the Chapter 7 trustee. In the Middle District of Tennessee, which covers every area that you all probably are marketing in, it doesn't include Knoxville, doesn't include Jackson and everything west, but it does include basically Cookeville East and Jackson West. Those are the eastern and western districts. Everything else is in the Middle District. There are 5 Chapter 7 trustees. They're called panel trustees, and they are fairly reasonable people. Their only purpose is to maximize the value of the bankruptcy estate. In real estate, as soon as you file the case, all assets become part of that estate. So if you see a Chapter 7 case get filed, just know that that owner of the property on the deed no longer has control. They have possession, but they don't have any right to sell it, because that property has been included in the bankruptcy estate. So your client would be one of the 5 Chapter 7 panel trustees. These Chapter 7 panel, yes.
Let me ask a question. We've got different states on here today as well, because they're from the place organization across the country. How would someone go about in their state, if you can share that, finding out who their bankruptcy trustee is, or finding the attorney there, just in a real quick synopsis?
Sure. You would go to pacer.gov, pacer.gov, and it is you can get access, you can get an account where there's a login and a password, and then you're going to have access to every single bankruptcy case filed in every single district. And for purposes of this call, the bankruptcy code is federal. So it doesn't matter if you're in California or if you're in Texas or if you're in Tennessee. Everything I'm saying is going to apply the same. It's just going to be, instead of 5 panel trustees, there might be 1, or there might be 3, or there might be 7. Regardless, it's the same. So if you get that pacer.gov account, you can then look at the bankruptcy docket, just like every newspaper crawler does when they go to report and publish those cases. You can get that information, and you can filter that search by district, and you can filter that search based on the chapter filing. So you can see real time what cases get filed every day. And I know that because when I file a case, as soon as I file it, within a matter of literally seconds, my inbox is flooded with different investors who are emailing me saying, I see that you have real estate for sale, or I see that you have real estate as part of this. Are you interested in selling it? And they don't understand that as the attorney, I don't have any control. My client doesn't have any control. It's the trustee. But they send those emails, so I know that there are a lot of people who are looking at this docket. And the very first filing in every single case contains the bankruptcy petition and a schedule of assets and liabilities. So when you go to open that case, you'll see on the very first docket entry if they own real estate. And that document then shows what is owed and on the property. So it shows the debt, It shows who the holder of the deed of trust is, and it also shows what the approximate value is, which you can do on your own. And it's just the debtor's attestation as to what they think it's worth. But that's a very quick snapshot over the course of an hour. You could look through 15 cases. I would say an average of 4 minutes per case to click on it, click on the schedules on the petition, scroll down to see if they own real estate and if that's a potential opportunity. And so I say 15 in an hour, you'll get it down so it's about 30 seconds per case once you do it for a few hours. And so you can run through every single bankruptcy filing in your district in a matter of minutes every day if you wanted to. And you'll see right when you open that case, top right corner, it's going to say who the trustee is that has been assigned. If it hasn't been assigned yet, because sometimes there's a lag, you'll be able to check it within a day and a trustee will be assigned to it. So from a notice standpoint, pacer.gov is really a huge resource that lawyers use it every single day. I'm on Pacer every single day doing the exact same thing that you're doing. I'm just looking for different things than what you would be looking for.
Now, as a pre-foreclosure, I'm talking to a client and they're, most of the times they're going to be embarrassed that they've got to this situation, feeling hurt about it. So when I do talk to them about, what those options are that they have at this point, because they've been issued that notice of default, if bankruptcy does come up, what is the protection that they do get from a reorganization? What do they get to keep, and what are things that are shielded by the bankruptcy?
So once the bankruptcy case is filed, then an automatic stay goes into effect. No creditors can take any action. They're just stuck there. And they can't do anything because the bankruptcy code is intended for Chapter 7 purposes to give the trustee an opportunity to market and sell the property. For Chapter 13 and Chapter 11, the reorganization chapters, those are intended to give the debtor breathing room space to be able to receive income, build up a reserve, and clean the slate and have a life going forward. So what it looks like is if someone is in pre-foreclosure and they need to know what their rights are, if they haven't spoken to an attorney, then they, in a reorganization case, they have the option to be able to try and retain that property. And when I say retain the property, then if there's a mortgage associated with it, they can file, it's called a statement of intent, is to say, I intend to keep this property. And if I'm going to keep it, then I know I have to pay for it. There is no world in which someone can keep the property if they can't service the debt on it. So if they can't afford it going into bankruptcy, then there's a good chance that they couldn't afford it in bankruptcy or after, and that's a property that they're going to sell during the reorganization process. In Chapter 11 and Chapter 13, and for your purposes, I'd really focus on Chapter 13 cases because Chapter 11 is such a small number, and Chapter 11 is for the high net worth individuals who probably already have a real estate contract and they're a little bit more sophisticated and they've gone through the process of determining how to best glide slope this thing into a good spot. So for Chapter 13 purposes, they might have filed for bankruptcy because of that foreclosure. So they might be able to keep it if they can shed a bunch of other debt and then they can have enough money to pay their mortgage. That might be the entire purpose of the bankruptcy. So I want you to think about it in two different lanes. You have a liquidation lane, Chapter 7, and a reorganization lane, Chapter 11, Chapter 13. Know that if they're going to be filing for Chapter 7, their ability to keep that is entirely dependent upon whether or not there is equity in the property.
Now, our lane is going to be in the reorganization part where they want to keep it or sell it, through us, through either an instant offer, listing it, or possibly introducing them to a subject to person that can get them caught up or whatnot, or take over the mortgage payments, if they come up with a sizable amount. What time frame do they have from that filing the bankruptcy to actually being able to either sell it or something of that nature?
That's up to them. There's a lot of discretion. So if I'm going to focus on the reorganization side, if I'm a debtor and I file for bankruptcy, the automatic stay goes into effect, so there can't be a foreclosure. I don't care if the bankruptcy case is 3 minutes before the foreclosure starts. If that foreclosure goes forward, it's null and void. It never happened, even though it was cried out at the courthouse steps. And so when you go to file the case, the automatic stay kicks in, and then the debtor is referred to as a debtor in possession. They get to control all their assets and manage their own affairs. They get to decide if they want to sell the property or if they want to keep the property. And so I do think that there's a lot of value in going to a Chapter 13 debtor to say, this appears to be some debt that you have, and this appears to be a property that if you were to liquidate it, then you would be able to rid yourself of this debt, and you would be able to have the benefit of some of the proceeds in order to confirm a bankruptcy plan of reorganization and have a good life after. One of the things that you should keep in mind, though, is that a lot of times Chapter 13 debtors, they don't want to sell their property during the bankruptcy case, because if it has equity in it, then that equity is immediately going to go to all the creditors. So Chapter 13 debtors oftentimes get through their bankruptcy case and then sell it after, but not always. There's a very reasonable assumption that you can make that you can sell the property for them during the case, and they can go rent or they can go buy somewhere else. But your goal is to discuss, communicate with them, so you can say, this process is going to require you to continue to make the payments on your mortgage. And I can see from the budget that you filed in that first docket entry, I can see that your budget is highly consumed by your mortgage debt. And if there's equity in that property, we can possibly assist you with selling that property, maximize the amount that you're going to receive, and that benefits you. It makes your bankruptcy case a lot smoother and cleaner, and it also paves a path for success financially for you going forward. So I would highly target the Chapter 13 debtors from a reorganization standpoint, because the debtor is the one who gets to decide if they're going to sell that property, and they can do it in the plan of reorganization where they propose to the world, this is my plan to reorganize, I'm going to sell my asset. Or they can do it in what's called a 363 motion. It's just a part of the bankruptcy code. Section 363 of the bankruptcy code allows a debtor at any time before or after the plan is filed to independently say, I want to sell my property, court. Can I get approval to do so? And so
Now,
that's
many times when someone files for bankruptcy, it is the property or the home that's essentially tipping them into the bankruptcy area.
Mm-hmm.
If they do sell it and they say, we're able to satisfy those debts because we're able to sell it for this amount, can they do like a mulligan and say, well, we don't need to be in bankruptcy anymore?
correct. So the beautiful part of a reorganization, again, we're not talking about liquidations because the debtor doesn't have any control. Once you file, you can't unfile. In a Chapter 13 or Chapter 11, the reorganizations, that is a very good strategy. And it's one that I employ quite a bit in my reorganization cases, is to say, you want to prevent the foreclosure. We know it's going to happen. There's been a notice. There's a date certain when it's going to get sold. We all know what happens in foreclosures. The bottom feeders come out, and who knows what the actual amount of the sale is going to be. Well, if there is still an amount that's going to be owed to the bank, well, that foreclosure just means that the bank doesn't have any collateral interest anymore, because that foreclosure, it extinguished their deed of trust, but they'd still have recourse against that individual. And so they might have their house foreclosed upon, and then the bank's going to sue them for the deficiency that resulted from a depressed foreclosure sale. And now they have to file a Chapter 7 when they could have gotten the benefit without ever having to file bankruptcy at all, by going through the bankruptcy process and selling the property. And so they can maximize the value of that asset. So in that situation that you're referring to, you would go to them as a foreclosure, as a pre-foreclosure type asset, and say, you might be contemplating bankruptcy. There might be a way to avoid it. And one of the ways to avoid it is by working with the bank to say, give us 60 days, give us 90 days, give us 120 days, or even give us 30 days. Whatever it is, you work with the bank directly to say, I want to sell this property on the market, because we all know what happens at a foreclosure. So give me some time, and then they go under contract with you with a listing agreement, and then the debtor, the borrower, and the agent then work with the bank to say, hold off on that foreclosure, give me a chance to sell it. And then you never have to worry about foreclosure, and you never have to worry about bankruptcy, because once you sell the property, the proceeds from that are going to be higher, hopefully able to satisfy the mortgage, avoid bankruptcy. You've just gotten a commission off of it. The bank is happy and the debtor is happy because they don't have to file. So bankruptcy is only if your initial attempt to work with the debtor doesn't result in a continuance of the foreclosure, so that you can then operate, market it as you normally would, and sell it without the risk that it's going to get fire sold at the courthouse steps. So
now, what type of situations do I need to be concerned about with title? Let's say that the husband qualified for the mortgage, so the mortgage is just in his name, but when they did the actual sale, they put it in the husband and wife's name.
Yeah, so in that situation, there is, I think what you're referring to is, on the deed you have husband and wife, but on the mortgage you have, say, husband only. In that situation, in order for the bank to ever have given that loan in the first place, the spouse has to waive her marital interest. So from a title standpoint, the bank is going to foreclose on the asset. It's not going to hurt the wife's credit in that situation because she's not a borrower, but she does have an interest in the property. But the bank's deed of trust has her signing off on her marital interest. She's waiving it, so the bank can foreclose. It's not really a title issue. It doesn't create a title issue, because that deed of trust that's being foreclosed upon, that is going to clear the title, because it's going to divest both of the husband and wife of their ownership interest in that property. And then the bank's only recourse is against the husband, because only the husband was the borrower. It's just that the wife kind of got drugged through the process by virtue of the husband's debt, and her home might get sold because she previously waived her marital interest in the deed of trust that gave the bank the right to foreclose.
And then I've got one other question, which kind of takes it to a very small percentage. Let's say that they get divorced at some point. The house is awarded to the wife during the divorce proceedings, but the mortgage company was not contacted as far as for the asset, and the husband's still paying the mortgage, or it's still in the husband's name, even though she may be making the payments now.
Yeah, so if there's a divorce situation, then that either marital dissolution agreement or the final decree is going to decide who has to pay for it. Well, that dissolution agreement or that decree, it doesn't change, that in and of itself doesn't change the ownership. So if the wife gets awarded the property and she is now the deed holder, but the husband is still responsible for the obligations, well, if that husband ever stops making the payment, then the bank can still foreclose on the property, because that deed of trust was recorded. And as long as that wife had waived her marital interest, it doesn't matter what the divorce decree says. It doesn't matter what the marital dissolution agreement says, because it can't change the bank's lien rights that it would have to be able to foreclose in the event that there is a default under the mortgage. It would just mean that that husband's going to get in trouble with the court, possibly sanctioned, because he was unable to continue making the payments to the bank as required by the court order. But it doesn't affect title there at all. I think that there's a big opportunity, because I have a lot of clients who contact me, and they're reorganization clients, and they say, I got this notice of foreclosure. I want to keep my property. I think that there's equity in it, but I can't service the debt right now because I have a bunch of medical bills. I have a bunch of credit card payments to go through. I've guaranteed a bunch of business debt. All these other debts that are associated with it have caused them to be unable to service their mortgage. So they're looking to go file for bankruptcy. And there are so many cases where they never get to bankruptcy, because I call the bank and say, hey, I understand that you're foreclosing. I think that we can sell this property and we can avoid potentially bankruptcy, because if we sell the property, then the loan can get satisfied in full. there will be excess proceeds that can then be used to pay other creditors, and a bankruptcy can be avoided. Even if a bankruptcy can't be avoided, you still sell the property, and then the bankruptcy looks a lot cleaner because there's no mortgage associated with it. They can file a Chapter 7 and discharge all their debts. So the pre-foreclosure type of properties are huge to market. So you have a stressed out debtor, they want to avoid bankruptcy, and they want to avoid a foreclosure. It just requires the borrower and oftentimes the agent to work with the bank to convince them that if they sell it on the market, they're going to get X dollars. And the bank is always looking for that. So at a foreclosure, maybe nobody shows up. The bank has to buy it back. Now the bank has to carry that cost, get insurance on the property. They're responsible for the taxes. Banks aren't in the business of owning property. And so they are looking to the agent as the professional to say, do I trust you? Do I think that you can actually get this sold within 90 days? And are you credentialed enough to be able to be the one to do it? And if the answer is yes, banks will oftentimes say, okay. The only difficult time is if there's a bunch of equity in property. Banks don't care. Banks are going to say, I don't care if it's sold at foreclosure or not. Its property is worth $800,000. You only owe $350,000 on it. There's no world in which I don't get paid in full. I'm just going to foreclose. It's those properties that don't have a lot of equity in it or don't have any equity at all, where a bank is looking to mitigate its losses, and they will work with the borrower to extend the time that they have before the foreclosure happens. That's why if you show up to a foreclosure sale and there's a list of 10 properties that you're thinking about or your clients are thinking about buying, well, you get to the foreclosure sale, 7 out of 10 of those are just announced as continuances because the borrower has made a good faith payment or they've worked out a deal with the borrower and a borrower's agent to postpone that foreclosure to give them time to sell it.
Hey, Griffin,
So,
quick question.
Sure.
So, and sorry if you have already discussed this, what's this timeline on foreclosure from the process of which, like, is it the 3 months if they don't pay within that time, it's just done, or do they have basically how much time do they have so they can get this thing back?
Yeah, once they default, it always depends on the bank, and it depends on the bank because the bank has certain cash reserves that they have to maintain. Sometimes they just really want the cash. So if you have a default, some really aggressive banks will send a notice of default, which gives the borrower 10 days to cure. And if they don't, they immediately file their appointment of a substitute trustee, and they send out notices of foreclosure to all parties in interest. So some banks, from the time of default until the time that notice starts, it could be a month. Other banks, it literally could be years where they don't want the property. They're just sitting on it, and they know that there's a certain value there and the market's not depreciating. They actually want the benefit of time because they think that the property is going to appreciate based on where the market is. So from the time of default until the foreclosure process starts, that could be months. It could be as little as 1 month. It could be as long as a few years.
Okay.
Once the foreclosure starts, it's usually about 21 to 30 days before the foreclosure is scheduled to occur. And that's because it has to run in the newspaper 3 times in order before there can be a foreclosure. So if you go to look at the newspapers, then you'll see publication number 1, publication number 2, and then it'll oftentimes say in the notice 3rd publication. And that's when you know it's getting close.
Okay. So basic situation where if my client has got that type of thing going on, I need to be contacting the bank, like you said, and trying to beat that system to get the thing sold beforehand and make a deal with them. Yeah,
your first order of business is contacting the borrower. You establish that relationship, and it's a script that you should develop. I'm happy to review it, but you are the sales professional, so you know how to say it. Say, hey, it could be a simple conversation where I'm really sorry to hear that your property might be subjected to foreclosure, that there has been a default. And the pre-foreclosure properties on Zillow, by the way, are because there's been an appointment of a substitute trustee that has been recorded with the Register of Deeds. And so all the crawlers, all the aggregators see that. And there's only one reason for the appointment of a substitute trustee to be recorded. Because those notices of foreclosure, those aren't recorded. Those aren't a public document. They only get sent out to the individuals who have an interest in the property. And so the appointment of a substitute trustee is going to have a lot of people mailing that borrower to say, I can help you, I can give credit relief, I can do all these different things, that those get trashed immediately. Once you see that pre-foreclosure property, then it's worth trying to find out a cell phone number, trying to find out if you can make a personal contact with them. And then it's just a gentle conversation of saying, I'm really sorry to hear what you're going through. I know it's stressful. My job here is to try to alleviate that stress and hopefully allow you to be financially successful going forward. I think I might be able to do that. I've looked at your property and I've looked at these comps in the neighborhood. I think that this is a good market value for your property. At a foreclosure, it might be 1/3 that. It might be 1/2 that. And that, if there's a foreclosure, after the foreclosure, the bank might still come after you because they're going to have the right to sue you if there's any deficiency. I want to help you here. And if you'd like to have a conversation, please allow us to engage in this dialogue. And I think I might be able to help. Once you develop that relationship, then you and the borrower contact the bank to say, we're aware of the foreclosure that's being set. That's not in anybody's best interest. We can maximize the value of the proceeds for the bank's benefit, but we need a little bit of time so we can really market this property. And this is what we're seeing in the market. They're sitting on market for this number of days. Here are the comps. This is what we can do for you. So you got to do your research going into it. Otherwise, I think you're just going to get put in the same category as everybody else who kind of just spams them. And I know it because my clients say, yeah, I've gotten a bunch of stuff. I just trash it all. But the people that they don't trash are those that make a personal contact and who have done their homework to know the value of that property and the time that it was going to take to sell. And then once you present them with that opportunity, then it's a dual effort going to the bank to say, give us a little bit more time. And you know who the banker is oftentimes because they signed the deed of trust.
Gotcha.
And so that's, who the bank is, who the banker is. And if they don't know, your borrower is going to know because they probably have a loan officer or a contact. It is very rarely the situation that where the borrower doesn't know who their officer in charge is. It's usually gone to special assets by that point. And so that notice of default that they received is going to include the bank's contact information and who the banker is to get you directly to them. But you're never going to know that until you establish that personal relationship with the borrower. I think I saw a question come in. Then a pre-foreclosure ask. Yes. Yeah. So exactly, Wes, you had just posted, if in pre-foreclosure, ask for the loss mitigation department or foreclosure department. And that's what I refer to as special assets. So exact same concept, just depends on the state. So yes, you're going to want to know who that special assets officer is. And that your next point is spot on. If you were to contact the bank directly, they're going to say, I don't know who you are. I need a power of attorney. I need the debtor to contact me or the borrower to contact me. And that's why I was saying it's a dual effort where you both contact the bank. And that's when the borrower can give you the authority to act on the borrower's behalf to negotiate with the bank directly. And the bank will feel like a little bit of an examination. I've sat on them before. I've contacted the bank and they ask for comps in the neighborhood, what the anticipated sale price would be, how long is it going to take to sell, and are there any title issues that you can foresee as being a problem? Because anybody who's going to buy at a foreclosure is going to identify no problems either because they've conducted a search. And so you'd want to know on the front end, what am I possibly looking at here?
Any other questions?
Jana, did you have one? I saw you're chewing. She's chewing.
Okay, sorry. So originally you had talked about on the chapter 13 that sometimes it's better to wait until the foreclosures, the bankruptcy is over, because to avoid the bank suing them afterwards for the rest of the assets. So I guess can you clarify, obviously the best thing is when it's pre-foreclosure, have that relationship, but if it's in the chapter 13 status, what's better to help them sell it, like during that process or like once bankruptcy is, I guess, complete?
Yeah, so the problem with, so that's a bankruptcy strategy where people will wait until their case is over, but cases aren't over for 3 or 5 years.
Okay.
And they wait for that time because they know if they sell it, they're going to get a bunch of equity. And if it's still in that 3 or 5 year period, depending upon how much money they make, then all of that equity is immediately taken by the Chapter 13 trustee and dispersed to creditors. So all my reorganization clients, I say, keep making your plan payments. Wait until after the bankruptcy. Once you get that discharge, then sell it. Then you get to keep debtor 100% of the equity. But during a bankruptcy case, I think it's still important because people default on plan payments all the time. Less than half of Chapter 13s successfully get to discharge. And that's because they can't make their plan payments. One of the reasons they can't make their plan payments is because they can't afford the mortgage. And so once they file for the bankruptcy, don't think that, oh, I've lost this one. That's not necessarily true. They can get fired from a job. They can have other issues in their life that they want to move. They want to get away because now they have this stigma attached to them. They want to move. And so I would not just abandon that opportunity, but I think that your pre-foreclosure type of properties are where you're probably going to get the best response from
Okay.
borrowers.
Yeah, thanks.
So,
Any other
Wes,
questions?
I hope I didn't take up too much time.
All right, this is being recorded. It'll be on Tennessee Power Up on our YouTube channel. Just go to Ben Kinney team if you guys need it. I can send the link to you through our Happy Place on Facebook. But I appreciate being on there. Griffin, thank you so much for being on with us today.
Thank you. If you have any more questions, always let me know.
All right, thank you.
All right, thank you all.
All right.
All right.
Thank you.
Bye.